So is she trying to jump out of a moving car and he's pulling her hair to keep her in? Well, but then the witness sees them outside of the car arguing, and then he pulls her hair outside of the car.
I heard that. I did hear.
Wait a second, pulling her hair inside the car, and then again outside. That's not a minor misunderstanding. That's a potential pattern of aggression. And remember, eyewitness testimony, even from strangers, carries serious weight in probable cause hearings.
So the witness saw the defendant and the complaining witness inside the vehicle fighting. The witness tried to get the complaining witness out of the motor vehicle, and then the defendant pulled her back by her hair.
Are we supposed to be happy you're on bond for an assault? And you pick up a new assault. Come up.
No, this has very valid explanations that I think the court will want to hear in the situation. It's a very unusual situation.
What time does court start? Mr.
8:30.
What time did you get here?
I didn't have to come today. After the 4th, I was supposed to communicate with my lawyer.
I ordered you to come here today.
Let's pause here. The defendant is already out on bond for one assault, and now, a second one. That's not just bad luck. That's a judge's worst-case scenario. Bond is not freedom. It's a test, and he just might have flunked it.
A new case. You are on bond for an assault. You now have picked up a new assault. You are now facing another year and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Defendant and the defendant dating relationship. On 11/27/24, officers were dispatched to an assault in progress in Harris County, Texas. Officer met with other officers who had already detained the defendant.
Now this is where it spirals. A stolen purse, a flash drive, and alleged scam materials. We are not just in domestic violence territory anymore. This is drifting into felony fraud, digital evidence, and motive. Prosecutors love when a case starts to connect the dots.
The officer spoke to the complaining witness, who stated the defendant pulled her hair at the house and that she felt pain. She stated that they had been driving down Westheimer and the defendant attempted to take her purse that had a flash drive that had fraudulent scam material on it. Complaining witness said that the defendant was trying to scam San Jose gas oil, and the information was on the USB drive. Complainant stated that they started to fight and she scraped her hand on the purse and felt pain. Complaining witness also stated no threats were made and the suspect did not put his hands on her. Defendant stated they were arguing in the car and the complaining witness slapped him twice and scratched him. Defendant stated he felt pain. The witness stated she worked security and she saw the traffic was backed up, so she drove up and saw the complaining witness and defendant in a stopped car in the street. She said she saw the complainant and the defendant fighting. The complaining witness was trying to exit the vehicle and that's when the defendant pulled her hair. Witness stated the complainant exited and ran across the street and called 911. Officers observed blood on passenger window where complaining witness was sitting. Officers also observed complaining witness to have injuries to both hands.
Your Honor, no, the one thing I just wanted to point out was more on the dates, in that apparently he thought that the new case was set for December 5th. This document, it refers to December 5th, but down the bottom, it looks like then it was ordered that he appear at the court's next docket on Wednesday, December 4th.
Boom, probable cause found. This isn't a conviction, but it means the judge believes there's enough evidence that a crime likely occurred. That unlocks the courtroom doors for prosecutors and locks the defendant's chances of a quiet exit.
Because the original case that we've been here for, the first case, his appearance was waived on that case. So he got confused and thought it was waived, and I think he was
ordered
supposed
him to appear because of the new case that he picked up. So regardless whether he comes at 8:30, he comes at 9:30, I don't think I've ever taken someone in for coming in at 11:30, for coming in at 12. But I do have a problem when you pick up a new case.
Yes, sir. And
It's alleged here that you have assaulted this person, and they have now provided me with enough evidence that I'm going to find probable cause that it occurred. Joe?
Your Honor, the only thing I can say is,
Okay, now we have got some serious back. Was he pulling her hair to keep her safe from jumping out or to control her? This is where courtroom narratives collide. Intent matters. And if a jury hears conflicting versions, credibility becomes the battlefield.
the client has vigorous defenses, and obviously this is not the appropriate point to point out. But I don't know, was the complaining witness out on probation at this time, or because she herself was under some legal
All I know
infirmities?
is that
Very
is it
serious.
2 times that he pulled her hair, or was it just 1 time? It sounded like it was
Just a one-time, Judge.
He was trying to prevent her from, she was gonna go out with the moving vehicles, what his position was. He was trying to keep her from getting hurt, from going out of the moving vehicle.
I didn't hear anything about that.
Because I believe what happened is she called and reported this afterwards. They left the scene and then she called, phoned it in and reported it afterwards.
So is she trying to jump out of a moving car and he's pulling her hair to keep her in? Well, but then the witness sees them outside of the car arguing, and then he pulls her hair outside of the car.
I heard that. I did hear that,
So
Your
the
Honor.
witness saw the defendant and the complaining witness inside the vehicle fighting. The witness tried to get the complaining witness out of the motor vehicle, and then the defendant
Picked up a new
pulled her back
case.
by her hair.
Are we supposed to be happy you're on bond for an assault? And you pick
This is the defense's humanization play. Kids, a sick mother, financial struggles, all of it is true and often tragic. But here's the thing, sympathy does not erase evidence. Judges balance hardship against public safety. And with 2 assaults, cases pending, that scale tips fast.
up a new assault.
Yo no daría daño nunca a la persona que
Well, now is, I mean,
I would never hurt somebody that I'm with.
por favor, me refiero que diga su señoría. Ella es mi novia. Ella ahora mismo está en la prisión.
She's my girlfriend. She's right now in jail. He has
Porque ella está en viciada en la droga.
she has problems. She's
Yo quiero-
drug addicted to drugs.
Yo quiero que ella lo
Hey,
hospitalice.
I want her to be
Yo soy la-
hospitalized.
yo soy la-
you,
The only reason that was relevant, Your Honor, if I could help him out, is that he did tell me beforehand to help the court and the system, is that she has been his girlfriend for many years, and that he has 1 child he supports along with his mother, who's here today, and he works as a driver, and he does support them all. But she does have this problem with drugs and has this pending case. He himself suffers from depression and diabetes, but he does manage to work in order to support them all. If these are just things that maybe the court could consider, because it would be a big hardship for them to lose the income. Now, he would agree to any kind of additional controls in terms of staying away from her, but maybe 200 feet away or things like that, because she's not